Ready? Started. When the matter went back to the Chief Judicial Magistrate, he recorded the depositions of the complainant and also the witnesses afresh and came to the conclusion that a prima facie case under the provisions referred to above has been made out against the accused persons. Summons were accordingly directed to be issued to the accused persons aggrieved, whereof the appellant filed a revision petition before the additional sessions judge, which failed and was dismissed inter alia, holding that the material on record before the court below did make out a prima facie case against the accused persons and that there was no legal infirmity in the order directing issue of summons to the accused persons. The appellant preferred a petition under section 482 of CRPC before the High Court of Jharkhand, Ranchi, which was dismissed by the High Court by the order impugned in this appeal. We have heard learned counsel for the parties but find no reason to interfere with the order under challenge. It is fairly well settled by a long line of decisions rendered by this court that the power vested in the High Court under section 482 CRPC can be invoked for quashing an ongoing investigation, complaint or other proceedings only in case where either there is legal power to the continuance of the proceedings, such as the absence of a sanction where required or where averments made in the complaint or first information report, even if accepted on their face value, do not constitute an offense, or where there is no legal evidence to support the charge made against the accused. It is also fairly settled that the powers vested in the High Court under section 482 CRPC have to be exercised sparingly, and that the court cannot be called upon to appreciate the available evidence or material with a view to find out whether the charge leveled against the accused stands proved. A plain reading of the complaint filed by the complainant in the instant case makes out a case against the accused. Not only that, the depositions of the three witnesses examined by the complainant in support of his complaint also support the allegations made in the complaint. The magistrate was therefore justified in taking cognizance against the appellant and the co-accused. The Revisional Court of Additional Sessions Judge Dhanbad was also correct in holding that a case for issue of process has been made out. Such being the position, the High Court committed no error in declining to interfere under section 482 of CRPC, nor is there any reason for us, much less a complaining one, to take a view different from the one taken by the High Court. In our view, the Chief Judicial Magistrate had committed an error in recalling the witnesses and examining them afresh after the matter was remanded back to him for further inquiry, and the directions for a further inquiry could not be taken to mean that the magistrate had to record afresh the depositions of the witnesses already examined before him. The matter, as noticed by us earlier, had been remanded back to the Chief Judicial Magistrate to hold a further inquiry. That decision and direction did not necessarily oblige the magistrate to record any further evidence in the case. The nature of the inquiry was in the discretion of the magistrate, which may or may not have included recording of further evidence on behalf of the complainant, the magistrate could, without recording any further evidence in the matter, reapprise the averments made in the complaint and the material already on record to determine whether a prima facie case was made out against the accused persons. There is a clear-cut and well demarcated sphere of activity in the field of crime detection and crime punishment. Investigations of an offense is the field exclusively reserved for the executive through the police department. The executive, which is charged with a duty to keep vigilance over law and order situation, is obliged to prevent crime, and if an offense is alleged to have been committed, it is its burden duty to investigate into the offense and bring the offender to book. Once it investigates and finds an offense having been committed, it is its duty to collect evidence for the purpose of providing the offense. Once that is completed and the investigating officer submits report to the court requesting the court to take cognizance of the offense under section 190 of the code, its duty comes to an end. On a cognizance of the offense being taken by the court, the police function of investigation comes to an end, subject to the provision contained in section 173(8) of the code. There commences the adjudicatory function of the judiciary to determine whether an offense has been committed, and if so, whether by the person or persons charged with the crime by the police in its report to the court, and to award adequate punishment according to law for the offense proved to the satisfaction of the court. ये जो कंटेंट आपको बोला गया है ये 143 और 144 है लीगल का 3P का कंटेंट है, और ये जो वर्ड आपको बोले गए हैं इसमें वर्ड बोले गए हैं लगभग आपको 825 के आसपास वर्ड बोले गए हैं, और जिसकी स्पीड है 110 के आसपास। ठीक है, अगर आपने अच्छा लिखा लिखेंगे, नहीं तो मैं आपको एक और कंटेंट बोल देता हूँ, आप उसमें कंटिन्यू करेंगे। नेक्स्ट कंटेंट आपका लगभग इतनी स्पीड पे 110 के आसपास बोलता हूँ। रेडी?